Guerrero was right about the shoe. The shoe was not the same in the picture in court as the shoe pulled from the evidence bag by Trooper Bukake.
And you mentioned you're at the hospital. There was a sneaker. One.
Yes.
Bukake! Bukake!
Woo! Good afternoon, my friends. I hope everyone. Good afternoon, my friends. Try that again. I hope everyone is doing well. Oh my goodness, look at this right out of the gate. Andrea sent a $10 Venmo. Says, I'm hoping you can unshadow ban me from your chat. I wrote to YouTube and they said it was a glitch. I'm on the block list. My handle is it's me, Andrea 1017. Well, you're gonna have to wait, Andrea, but I appreciate the Venmo. Thank you so much. I've hit a lot of people in the last couple of days because people don't think before they comment. And I like to teach those people a lesson. Because when things are in the community the way that they are, there's hot, cold, warm, and you don't know what to do and you don't know where to go, and then people get all fucking, oh well, you know what, I'm this person and I'm gonna blah, 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 and you don't even really, you're not really judging the situation for what it really is, and you think that you're impressing people by taking a side. And I like to fuck those people off because it just entertains me. It's fun. Yeah, and I know, I get it. A lot of people are here very much, still kind of reeling from the drama that has taken place just a little while ago But don't worry. Even though I'm not talking about that here on this live stream, because people, you know my rule. Now, I do break it on very rare occasions, okay? But I like to try to keep the drama separate if I can. These last couple of days, I did not make them members only, but I like to I like to keep the drama behind the members only paywall, to keep them nice and separate, to keep the worlds separate a little bit if I can. So there is a petty set, and it is in the works. It's happening. It's not even in the works. It's set. It's happening. 4 p.m. Eastern. Petty stream. It's happening. I owed you guys a petty. I was going to do a petty. And I realized that Aiden was under the impression that my petty that was set the other day, yesterday or the day before, the day before, the petty that was set day before yesterday was about him. No, that's not the case. It's just that it was I called it the forbidden petty out of sarcasm and a little spite. But the petty itself was definitely out of spite, because Aiden and I were in a place of misunderstanding and anger, and but the subject at hand is the anger that I was feeling at the time. And I was like, you know what? Who the fuck is anybody to tell me what the fuck I'm going to do with my channel? It's the one thing that Just Machado said earlier that I agreed with. But I thought, who's anybody to tell me what the fuck to do with my content or my channel? And so it was spiteful, but not, it was not, Aiden was not to be the subject of it. I was merely discussing and explaining why I was doing the petty, and Aiden jumped in the stream, in the chat, and then jumped on panel, and then we argued, talked, squashed. That's what reasonable adults do. It's human and it's normal to take issue with someone and get pissed off about it. But you address it, you talk about it. And man, the antis, man, they were really, they really smelled blood, man. They were like, ooh, glare's flipping, glare's turning. And then when two adults actually come to a peaceful resolution, two reasonable adults come to a peaceful and reasonable resolution, it's very disappointing for people like that. Oh, the glare, he cowered, he bent, he gave in. Like, okay. But I don't do these things for the fear of what trolls are going to say about me. I discuss things that I discuss because I care about the dynamic that I have with my audience. Because I worked really hard to build it. I didn't do it off of the back of somebody else and expect to be praised for it. And absolutely show no gratitude for it. But let me address some of these before they get all. But we're going to discuss all of that in more depth. I don't want to go on a tangent here, but we are going to discuss all of that in more depth in the petty stream where it belongs. Rachel became a new member. Welcome to Reprobates. And it's good to see all my reprobates in here. Leslie, thank you so much. Nanya, MJ, Lisa, member for 6 months. Curious Liz, member for 10 months. You and Aiden gave a great example of talking it out. Thank you. Appreciate it. 1977 Felicia, love when two good mature men work out their issues and end on good terms. And Jessica, thank you so much. Appreciate it. Welcome. Welcome to Reprobates. I loved the Glare and TB stream. It was fire. Thank you, mom of four, Denise. And Sunny Days, member for 25 months, still here. Love it. Love it. And Robin G gifted 5 memberships. Holy, oh my God. So yes, we're going to let's see, what time is it now? Okay, yeah. This won't be a 3-hour live stream, I don't think. Probably just about 2, because we're just going to go over. First off, I want to say Happy Freed Day. I'm calling it Freed Day, okay? Fread. Happy Freed Day. All right? Because a year ago today, Karen Reed was acquitted of the bullshit charges against her for the murder of Boston police officer John O'Keefe, but the killers are still out there, and we are here to apply pressure using our First Amendment rights to do so. Next witness, member for 7 months. It's good to see you. Happy acquittal anniversary. See, that's too many words, bro. It's too many letters, bro. Freed Day, bro. Freed Day. Happy Freed Day. See what I mean? Look at that. It's catching on. I love it. So, we know that Karen Reed, there's all kinds of lawsuits flying around. I don't think I need to catch everybody up here on all the lawsuits. The cool thing about, being in this little community here is I'm not real worried, at least yet, of when it comes to building an audience. People, as many people are that could fit in here, are welcome, of course, but I'm not too worried about that. But I do want to talk about the things that are important and celebrate with you guys here. Gerda K, member for 29 months. Karen Freed, next free Turtle Boy, 100%. And pinned at the bottom of the chat is Turtle Boy's Give, Send, Go or defense donation link. Lettero by Bettero, member for 21 months. Adults adulting, who knew? I mean, imagine that. Dina, oh my God.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Thank you so much. Dina, my Clara, happy Free Day. I honestly think my Dina impression is the most accurate. Y'all don't give me any fucking props for it, and it sucks. Kate always late, but Dina knows that she's my favorite too. Kate always late, member for 6 months. Always appreciate your levity and sense of humor. And I appreciate that you appreciate it. Absolutely. MJ523, member for 14 months. Happy Free Day. Agreed. Yes. 100%. Coco and Chloe. Irish poor face. Welcome to Reprobates. We love you. Gen X, Gen I Am, member for 7 months. Happy Free Day. Turtle Boy was right. 100%. 100%. So yeah, we'll get into all the Turtle Boy and Jess Machado stuff when we do the petty at 4:00 Eastern. Kim's Ladybug, member for 11 months. Happy Free Day. Now let's free Turtle Boy. Ren, member for 31 months. Let's go, Glare. Still love you after all these years. Still love you after all these years. So like I was in the shower and I was listening to the end of because like the stream ended while I was in the shower. I was listening to the end of the lack of accountability interview that I was listening to. And and I guess she plays like one of Jimmy's videos and like spoofs like Ace of Base, and like ever since then, like that song has been stuck in my head like since I fucking got out of the shower. I saw the sign and it opened up my eyes. I saw the sign. Peaches gifted a membership. Fucking Ace of Base. I hated that shit so much. I hated that shit so much. And believe it or not, I hated it worse than I hated Dave Matthews, but I hate Dave Matthews more now. Sorry, Mel. I love you, Mel. I'll always love Mel, but I hate Dave Matthews. Rhonda Hink, member for 8 months. Clara, we love you. I love you too. I love you too. Oh, bro. Listen, dude. Real quick before we get into anything, dude. If you guys, bro, like seriously, if you guys right now, if you guys are not subbed up to Judge Jolene, bro, you're missing out. You're missing out. Like, she is absolutely fantastic. So much fun. She is like, you guys think I'm funny. Like, she is just, I mean, she's a pro. She's literally a pro. First of all, she's literally a pro comedian. Like, she's just fucking quick. And hilarious. Like, the whole time I'm cracking up. And she has been giving an outside perspective to all of our drama, and it has been fucking hilarious. She's an equal opportunist roaster, which I love. She fucking shits on everybody, and it's hilarious and it's good. And I am in love with anybody who can actually be good at shitting on people. If you're not good at it, don't do it. But she is amazing. And so I dropped her link in the chat. Stop what you're doing right now and go subscribe to Judge Jolene. And I will wait in the meantime while you do. Okay. All right. I hope everybody's subbed up to Judge Jolene. She's amazing. She's fantastic. We love Judge Jolene. Now, and I did notice that she uses a lot of the same sound effects I use. Stop with the whole she ripped me off or I ripped her off. They're very, very common side effects to use. They're used in memes and videos, and everybody fucking uses them. It's just, yeah, so stop it. Very, very common sound effects. And she has like way more than I do too. She's way better at it. It's like, if I'm being totally honest, she's way better at it. She's amazing. But it is Karen Freed Day. It is Freed Day. Happy Freed Day to everybody. Let's go down a little bit of memory lane real quick before we start getting into the last two hearings. and that's what we're going to watch. But first, let's watch this magical moment. Those are genuine reactions. People who have been invested in this for at least 2 years. And this is Boozy Beauty's footage. Thank you, Felicia.
Little girl gun, got a gun from a gangster. Run, little girl, bang, hustle.
Am I gonna get copyright dinged for that? Probably, because it's on X. Let's watch the actual verdict here real quick. Let's relive that beautiful moment. Probably should have played that first, but you know.
Remain standing. Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict?
A year ago today, people. This all happened a year ago
Mr. Foreman,
today.
the verdict has been placed in this envelope and have been in your presence ever since.
Now, this moment, let me try and paint this picture a little bit better for you because I'm playing this at regular speed. But this silence right here, this that you're hearing, and as long as it lasts. So before I even play that, thank you for coming to YouTube, member. Welcome to Reprobates. Before I even play that, I want you to imagine, because I spoke with Nathan Reed on the phone the following day. He called me on the phone to say thank you for everything I'd done. He was so kind. I cried, and I was just overwhelmed with happiness. And he was describing, because we talked for a minute, couple minutes really, and he was describing how during this moment that I'm going to play you right here, the bailiffs, they don't really show you that too much, but the bailiffs got behind and stood behind everyone with handcuffs ready to go. And the way that Nathan Reed described that to me on the phone the next day was that this was just these moments were like the longest that he can ever remember taking place. And knowing that, this just seems so much longer. These moments right here.
Mr. Foreman, have the verdicts has been placed in this envelope and have they been in your presence ever since?
You can almost hear all the hearts beating inside that room.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you?
Look at this motherfucker right here, bro. Look at this motherfucker sitting back here, right here, bro. I think you're in somebody's seat, bro. Who the fuck do you think you are, bro? I think you're in somebody's seat.
No. Do you agree? Yes. Do all of you agree? Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
How
Is
dare
not
you?
guilty or guilty?
How
or
dare you?
Any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman? So say you all?
Yes.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? The defendant not guilty or guilty? So say you, Mr. Foreman?
Listen to that crowd.
So say you all? Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to do that with
Bro, like even Bob, like you see Bob, he's so mad that Aiden took that seat, bro. Like, look at him. He's so fucking mad, bro.
What could be more egregious? What could be more misleading than that? And what could be more important?
Exactly, Bob.
talk with you a little bit. after.
Exactly.
Thank you very much.
All rise. Jurors, follow me.
Bro, the cerebral ninja in that state of vulnerability will never ever like not resonate with me deeply. It'll never happen. Like that's just amazing.
Media, please exit the courtroom immediately. Karen Reed.
Not yet.
Everybody get the fuck out.
Karen Reed, Ms. Reed, can I have your attention? As required by statute,
Turtle Boy
I
was
must
right.
inform you that the records regarding the charges that you have
Turtle Boy was right. Gifted 5 memberships. Thank you so much. We appreciate you. Thank you so much. We appreciate you.
found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the request not to seal form, which is posted on the trial court's website on mass.gov. I cannot accept
Because
the form
it's
here in court. You must submit it to
free
the Commissioner of
day.
Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want
Bro, this motherfucker right here, bro, he's gonna steal somebody's seat and cry in it. The fucking audacity.
copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
And we would be prepared to go forward today.
Okay, okay.
It's amazing. It's amazing. And there you have Bill and Janet. Fantastic. Everyone's so happy. Look at Nathan. Nathan's thrilled. I mean, I didn't do nothing with the sound. They did, just so you know.
All right, so Mr. Yannetti, you're ready to go forward today as well?
We did
So,
it,
Mr.
Tommy.
Brennan, what's the Commonwealth's recommendation?
Commonwealth rules for sentencing, we recommend a probation, 1 year, 24D program.
So the standard that everybody else gets on their first time OUI?
Certainly.
Okay.
We ask that you be treated no differently, no better.
So I'm happy to do it. All right, thank you all.
1 year probation.
Yeah, we
1 year
know.
probation on docket number 002, the lesser included offense of operating under the influence, 1 year probation. Thank you. The 24D program is. Thank you.
Immediately. All rise.
Goodbye.
Yeah, I really, really wish I could have been there for that. But I got to watch the verdict on Annie's channel. I got to mentally prep for it with some of just like a panel of all-star law tubers. It was as good as it could have been for me, short of being there. I have no complaints about it at all. Now here's where we get to the fun shit.
No. Do you agree? Yes. Do all of you agree? Yes. Thank you. 002. What say is the defendant at the bar not guilty or guilty?
Not guilty.
Of?
Is not guilty or guilty about that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater.
Stop it.
So say you, Mr. Foreman? So say you all? 003. What say is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty? So say you, Mr. Foreman? So say you all?
Like, why are you not showing? Show the crowd.
1 is not guilty, and 002 is guilty.
There we
of
go.
operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back to service is complete. I'd like to come back and talk to you a little bit afterwards. So thank you very much.
All rise. Your quality. Please exit the courtroom immediately.
Karen Reed?
Not
yet.
Tony,
Hold on,
not yet.
hold on, everyone.
Sorry, Carrie, thank you so much for the Venmo. Appreciate it. Will, thank you for your continued coverage of all you do on your channel. Stick to the script with sarcasm, things to indicate sarcasm there, emojis. Thank you so much. I appreciate it, Carrie.
Karen Reed, Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the request not to seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
Ken, we would be prepared to go forward today.
Okay,
Perhaps we could approach sidebar briefly.
okay.
Eruption, and now the eruption, and now they are celebrating the moment that they've been waiting for years now.
That everybody else gets on their first time OUI?
Certainly.
Okay,
We asked that she be treated no differently, no better. No.
so I'm happy to do it. All right, thank you all.
1 year probation, and docket number 002, the lesser included offense of operating under the influence, 1 year probation. Thank you. The 24D program. Thank you.
All right.
Goodbye.
Oh my God, I'm falling. Come on, Vinny, get me on. What do you want?
Okay. How are you feeling right now?
It's the first time in my life I cried because I'm happy. This is amazing.
God damn. I'm sorry, but that's horrible, bro. Jesus Christ. Like, I mean, and I mean that with all my heart. Like, that is awful that you have never cried tears of joy until now. God damn. Well, I'm glad you finally got to experience it, lady. I'm glad you did.
I can't even talk.
How long have you been involved in all this?
Since before the first trial started.
Thank you, Superstition Mom.
Thank you. There's an eruption. Try to speak with some more folks here as we get. I think all eyes right now are on the front steps as the enormous crowd gets ready to greet Karen Read and her attorneys as they sing.
They're booing to pee-pee. They're booing to pee-pee. Thank you, Jewel Savage. And there he is. Perfect timing. Following immediately after the booze shifts the entire mood.
That eruption was Turtle Boy as he exited the courthouse.
That eruption was Turtle Boy as he exited the courthouse after stealing someone's seat.
They've felt the moment. Now they're getting ready for the next moment, which will be the celebration with Karen Read and her attorneys. I'm wondering how and when the O'Keefe family will exit the courthouse at this moment. I think that's another concern of everyone here with all they've been through. But the eruption is going to be deafening when you see Karen Read, Alan Jackson, David Yannetti, Robert Alessi, and the rest of the team and the rest of the family.
Probation is over. 1 year. He is freed. Look at Ted Daniel. Ted Daniel's awesome, bro. I don't give a fuck if you like Ted Daniel or you don't like Ted Daniel. Ted Daniel is a motherfucking thug, bro. And I mean that like he is a gangster when it comes to mainstream journalism anyway. For sure. The dude like is getting shit done.
There's Nick Rocco and the rest of the supporters who were inside the courtroom for the verdict. Never experienced anything quite like this. And the emotion is real.
She fainted and the bailiff was like, get up, get out of here. No more fainting.
No, people aren't faking it. They're not forcing it.
Oh my God. Free to see.
If you're just joining us, folks, Karen Read has been found not guilty by a jury in Norfolk County, Massachusetts. I've been calling it the retrial of the century because it's the retrial of the century. And the retrial ended with not guilty verdicts across the board. See some more of the security there. Again, we wait for Karen Read and the defense team to exit. I think everyone realizes what an explosion
Y'all
it
are
will be in
fucked up.
that moment of sound. Everyone's got their phones up now,
Bro.
recording the moment after.
I will always do this for the chat, bro. It's always gonna be my favorite part of this shit. It's the fucking chat. You guys fucking kill me, bro.
Experiencing the moment together outside of the courthouse. The only lingering question for me right now, though, is John O'Keefe's family, if they're going to take them out the back of the courthouse, because there is an exit out the backside, and I think that would be the smart thing to do for that family. But for Alan Jackson, David Yannetti, and Karen Read, this is going to be their moment. We've seen it through the years at Court TV several times. It's been a few years, though, since we've seen anything even close to this, because it's overwhelming support for the verdict that the jury handed down. I don't know if Matt Johnson can hear me. Matt, do you hear me?
Bro, sometimes my demographic really shows in the in the chat. Like, if you look at my demographic, if you look at my it's like YouTube's kind of version of like P&Ls, projections, that sort of shit. And somebody was just saying that Esty had the vapors. Because my demographic is like 85% women between the ages of like 40 and like 60. So somebody was like, the vapors. Nobody has said the vapors since 88, bro. Nobody.
Yeah, I can hear you. All the media is assembling right now on the courthouse steps. We're waiting for Karen Read and her team to assemble down and leave the courthouse. A lot of police presence.
Let me see. What am I trying to say? What you trying to say, Will? What am I trying to say? I'm trying to say you old. Too old for the earth.
Out here on the courthouse steps and on the sidewalk addressing the media. We're pushed out all the way to the edge of the street, and we are just anxiously waiting for all parties to exit the courthouse here. Now, I am wondering if some of the parties might choose to exit through the back. That's where the jury had been entering and exiting the courthouse until now, so we know that that's an open opportunity for them. But yeah, it's just a waiting game right now from my vantage point. We're at the podium waiting for Karen Read to address her supporters and address the media.
Matt, I can spot Nick Rocco's been on my...
Bro, nobody has used the word vapors in that context. Nobody. Without being in a pair of Capizio shoes, a shirt, a button-down short-sleeve shirt that says ID on the pocket, and Zeke Averici pants. Nobody.
Throughout all of this, one of the leaders in raising funds for this defense team. He's not a lawyer. He's never been involved in anything like this, but saw a cause, raised money, and helped this defense team. You can't put on a defense like this without the funding that is necessary for the experts, for the lawyers, for the expenses. You have a lawyer from California, you have a lawyer from New York. All that's got to be paid for somehow, some way, and that's another part of this story. the over $1 million that was raised for
Protein and
Karen
Petty.
Reed, much of it by the people you're.
Thank you, Protein and Petty. Let's see what we got here. Fitty and Proud, stuck home with massive migraine, and I'm yelling into the mic, reading her fucking comment. The irony. Glad to have something great to listen to. Indiana weather absolutely sucks. I can't believe you're listening to me with a migraine. Jesus Christ, I give migraines. What are you talking about? But thank you so much.
We're seeing right in front of this courthouse as we wait for the moment, and the moment is Karen Reed coming down, found guilty of only a minor charge of operating under the influence, which is tantamount to a throwaway compared to what she was facing for manslaughter, leaving the scene of an accident with a death involved, and of course, murder. So this is a win across the board.
And of course, murder.
It's a celebration.
Laying it on a little thick there, baby.
In the streets of Dedham, where they've closed down the street in front of the courthouse.
Thank you so much. And of course, murder. God damn, dude. Yeah, so we all know, okay, I don't need to catch all you guys up. We all know that there are multiple lawsuits flying around. These people are suing them, and then those people are suing them too, and then these people are suing another people, and then these are suing. Everybody's suing each other. So there is a hearing in the House defendants. I don't even know which fucking lawsuit this is, but this happened yesterday. This is a hearing, and apparently Colin Albert, who is one of the plaintiffs, so I guess this is the one where they're suing Turtle Boy and Karen Reed, I guess, or suing Karen Reed for defamation, accusing her of colluding with in plotting to commit witness intimidation with Turtle Boy. We all know that's bullshit. We've all been here. We've been following this shit this whole time. So we all know that's bullshit. But it's interesting because Colin's listed as one of the plaintiffs. He files a lawsuit, but maybe not in this case. I think this is a different case, but it's weird. He files a lawsuit and then he goes and he joins the Army. Go watch Broken Baker's stream from earlier today. He breaks it down really, really well. Broken Baker was awesome this morning. So big shout out to Baker. And so apparently he's refusing to give up his communications, and he went and joined the Army, and nobody knows where the fuck he is. So
and then he is.
And I'm going to speed this up.
You accepted the deposition subpoena. He was served a deposition subpoena for April 29th. And you talked about taking it off. Didn't go for it. When's he going to be available? At this point in time, Your Honor, I'm not sure. It'll be sometime in the fall. He's got 10 weeks training. He's in basic training right now. We have 1 hour a week communication.
This judge ain't having that shit. This judge is like, I don't want to hear about, because this judge, I can already tell the second that he just said, that's not going to happen. Not going to happen. He's already on to this whole fucking joining the Army bullshit. It doesn't fucking track. And they're being, for some reason, the Alberts have always been, there has been this weird pattern of behavior since I started following this case anyway, that I have consistently seen coming from the McAlberts. And that has been a pattern of behavior that indicates a protecting of Colin. Everyone seems to be very protective of Colin. And I mean more than in the sense that they're a tight family and he's the baby and okay. There's more to it. It's been very weird. Stories have been And the reason why it's weird is because stories have not added up. Everyone's story when they testified in Karen Reed's first trial contradicted the other when it came to Colin's whereabouts that night. And how Colin got home. So there's a lot of questions right now that are being raised as far as that goes. And they want to search his tech. They want to search his phone. And so he's not available, apparently. So supposedly he's in basic training and he's not going to be available till the fall. Bullshit. The judge is going, I don't want to hear that shit. No. There are civic responsibilities here. And these civic responsibilities had already long existed before this dude is going to go and join the fucking army. I see what's going on here, and I'm not going to make it easy for you because I see what you're trying to do. Fuck you.
I don't dispute what you're telling me, but I'm not going to simply rely upon a statement in court that a witness can't be produced until the fall. So go
Right.
when it can be produced before that.
I will, Your Honor. We won't go talk to him until Saturday. I'll talk to him Saturday briefly and see what we can figure out.
But it's not a matter of figuring it out. It's a matter of you saying, look, there's a duly issued subpoena. As I said in one of my pleadings, in this case, which you weren't involved in, a subpoena needs to mean something. Just as an attorney agreeing to continue needs to mean something. And it shouldn't end up in front of me in these.
This dude right here is fucking quaking. He's fucking quaking right now. Now you see Scott McGinnis sitting back here. You see Rich Schiffer right here. And you see Karen Reed looking over at this dude like, yeah, what's your weaselly ass gonna say right now?
I appreciate that, Your Honor. We're in a situation where we learned on the 20th, and we let them know the same day. I know they say there's games here. We informed them the same day that we found out this information that he had been accepted into the military and had a shipment date of June 2nd. We said, please take his deposition during this period of time. I know you want to take it. At that point in time,
Let's not put aside the fact that you represent him in another case.
certainly.
That was called, that was filed not that long ago.
Yes.
So certainly, maybe a party that's going to prosecute actions such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And
I like this judge, man.
10 weeks basic training.
I'm not gonna lie.
The military the Army will assign him that location of where his 10 weeks of basic training will be. He'll be on, like I was saying, Your Honor, he'll be on leave in the fall. So in terms of I appreciate it.
Let me just make it clear. We're not waiting till the fall. Okay. All right. It's going into this case on the 17th. Okay. You're going to go find out when he can get back up here and be deposed. Okay. Now let's talk about the status of any discussions between the attorneys as to the scope of the production. I agree with Attorney Tuxbury that the scope of the subpoena is excessively broad. I know there have been discussions, but I don't know where you're at now. Have you had any recent discussions?
No, the discussions are what are laid out. And if Your Honor is inclined to ask us to, we can continue to work on the document side and report back to you in a few days.
Yes, I mean, we've made our proposal, Your Honor, with respect to, issues about what this case is about, which is the death of Officer Keith on the night of January 29, 2022. He searched for all communications with law enforcement.
Stop it. Stop it.
This motion in response to that. I mean, we're happy to look at other stuff, but I think
Bama Noise, thank you for Bama Knowles, thank you for becoming a member. Appreciate it. Welcome to Reprobates.
Let's keep in mind, okay, that I know there's the other case, but you're talking about a non-party.
Understood, Your Honor. And I don't know if you would want to, but I'm happy to get some thoughts from you about what's because what Mr. Tuxbury is referring to is the extremely narrow 2 categories that they said we'll search for these and we don't have any documents. We search and we don't have any documents other than the text chain that's already public record. So I think that is certainly too narrow. But I also take your point to me that as it stands, the subpoena is too broad. There is obviously, as you are aware, Your Honor, there's more than wrongful death alleged here. The false narrative is part of the claims the plaintiffs have brought in this case, and that obviously relates to much longer than January 28th and 29th, 2022. So to the extent, A, there's burden.
I don't know that it extends 4 years.
And I'm not trying to argue it because I don't understand that you want to decide that as a fact right now. All I'm saying is it's broader, and this is kind of my point. I think it's broader than what Mr. Tuxbury and his team interpreted. You're telling us that you think it's narrower than what we interpret it, and that's taken, which is why I suggested we have a conversation about maybe meeting somewhere in the middle, and I'm fine doing that.
When can you have the conversation?
Tomorrow?
Yeah, I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting or something else.
I didn't join the Army, Your Honor.
I never know who has to call me because it's allocation of attorney, so you need to know who you're talking to. Yeah, I can have a conversation about that.
I'm available.
Obviously, as you know, this is a wrongful death case with a again, there's an intentional infliction claim based on a false narrative. In many respects, that false narrative claim is the other side of the coin of the wrongful death, right? If she has said things that someone else did it, and they show she actually did it, a priori false narrative. It's not the defamation case. This is not the harassment case, that the criminal harassment case is proceeding with respect to Mr. Carney in Norfolk County. And so we're happy to consult with them, look for more stuff. I think there's a disconnect because there's a different view of what happened here. And so I think they're frustrated when we say we don't have any documents because he simply doesn't have any. He searched. We're willing to consider searching for more and expand the time scope of that search. But, in likelihood, the answer is going to be the same.
I understand you stand before me representing a non-party.
Yes.
But we're all aware of the other case in which certain allegations have been made. So you're going to have to do some of the searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, I think, following the guidance of this court, this case is the wrongful death case. We're going to do discovery. We're doing discovery in the defamation case, and we're going to get
Bro, this judge is like a brick wall, bro. Like he keeps basically saying the same thing over and over again. This guy keeps arguing a fucking moot point. He's missing what this judge is trying to put down. This judge is saying, listen, fool, produce your client, contact him, do your job. Let your client know that he needs to fucking be here. I don't give a shit what you tell him. Just make sure that he's here when I tell him that he's got to be here because he's got a fucking subpoena. That's how this works. We're not doing anything other than that.
request, I'm sure that would be broader than that. That's a different case here. And so the issue I have, Your Honors, as a third party here in this matter, is resource issues, right? It's quite expensive here. We're gonna have to do this in a defamation case. That's gonna be different and separate apart from this one. So all I'm trying to do, Your Honor, is kind of ensure that I'm not needlessly harassing a third party here in this action. I appreciate what you're saying, Your Honor. We're gonna produce those documents in response to the RFPs when we get them, right? Obviously we are. We've already gotten one set of RFPs.
Oh, this is about the documents.
So
This is about the comms and shit.
In this matter, and my client in this instance is also a party to a defamation case originally filed in Barstow County and now appearing before Your Honor. But I think in terms of like the scope of discovery and forcing him to kind of like do duplicative.
I mean, same thing.
Excessively burdensome.
The judge is like, fucking produce that shit.
In this case, like I mentioned before, it's not before Your Honor. We had thought that consolidation for discovery purposes might make sense to avoid this.
See, with Judge Bev, Lally could just play keep away. You know what I mean? Like he just violated Rule 14 shit, just like it was nothing all day. You know what I mean? And Judge Bev was just like, oh, and they fucking laughed about it. I remember there was one hearing where they fucking laughed about it. And I was like, what is happening right now? This judge is not that, bro. Like this judge is like, dude, if I tell you to fucking give me something, I don't want to hear excuses as to like how long it's going to take and why you want to do it. Or like, why just do it. Just get
this kind of situation, and it was rejected. That's fine. I'm not asking you to address it. But
no, I don't think the hospitality defendants would really want to.
I will tell you, Your Honor, they actually said okay. not to speak for them, but they said okay to it. But that's these issues that I'm dealing with. I appreciate what you're saying with respect to the defamation case and discovery.
So I was watching a little bit of Something's Off with Rebecca and Mel this morning, and they were going over this. I didn't realize it was this one that they were. Yeah, makes sense now. And this guy, the judge says hospitality defendants. And was he actually referring to the Waterfall and CF McCarthy's? Because they're not defendants. Well, yeah, they are defendants. The O'Keefes are suing them. So, right. So, like, that actually works to describe them. But I don't know if the judge just misspoke and he meant to say house defendants, but he said hospitality defendants. So I was a little lost because I had just jumped into Mel and Rebecca's chat. So I'm a little lost. But yeah, so he was referring to, because I was like, yeah, because I even commented like that actually works to describe CF McCarthy's in the Waterfall because they're the hospitality defendants. Okay, so he was referring to them. Okay, thank you. Sorry, I get fucking lost on these things because I'm kind of stupid.
But that's why here, I think the appropriate scope for this case is, as you've laid out before, which is what happened to Officer O'Keefe on that night. And on that point, as we put out in our briefing, Colin Albert simply doesn't have a lot to say.
He's just going to start arguing.
Yeah, we'll consider Bert. No,
What depositions are scheduled for Monday? I should know because I asked you for the calendar. So I don't remember.
You know that Monday is
Who the fuck is Tuxbury?
Monday is Nicole Albert, but that's
Sorry, I'm way behind on the lawsuit stuff. I only know the cliff notes of like the latest updates that take place and shit. But I haven't memorized anybody's names and except for the familiar people from the
You
case.
said 13. Were you talking Mr. Buck? Okay. Let me just make sure.
Zoom or in person, Your Honor? In person.
Yes, that works.
I will not be available, Your Honor. I think I mentioned this at our Rule 16 conference. I'll be gone for a while.
Maybe you have someone that can report on the results of your discussions.
Certainly, I can do that, Your Honor. And that's part of the
Okay,
issue.
Tuxbury is Collins'
I have
attorney.
my colleague Kieran Murphy, who's here with me, co-opted into the defamation case. It costs money to do that.
Is that what Melanie went over yesterday?
He can respond without appearing before Your Honor, and then we can figure out.
We have no objection to making that easier, however we can. To the extent there's a way that Mr. Murphy can appear, we're fine with it.
Let him appear. Right?
Yes, I mean, I asked today. I understand that he's not pro.
Okay, thank you, Dizzy.
We have no
Telling. There's no vacation. After you talk during Roseburg.
Yes.
Anything else? You have other motions that are coming?
Yeah, we do. We have a motion to compel that's coming again next week. I think the opposition's due early next week. We filed with you.
A motion to compel.
There's
Lots of motions to compel.
Plaintiffs, I believe.
Last couple of years.
Additional information response interrogatories. That's it, I think. At the moment, I believe that's accurate.
Okay, well, see if you can agree amongst yourselves as to a date to have another hearing the week of June 29th on those motions. Soon to be filed, all right? You don't need to do it right now. All right, anything else?
Can we address one topic at sidebar briefly? Remember?
Bro, Bill Reed is such a fucking gangster, bro. That guy's so hardcore. Hey, Texas twig and berries. Y'all are amazing. And for future reference, just so you know, I'm not reading your comments unless it's in form of a super chat, okay? I don't have time, people, okay? My time is valuable. I get up here and I share my life with you guys all fucking day, okay? All fucking day, okay? So I don't have time to read all of your comments. If you're going to make a comment, it's got to be in a super chat because my time is valuable, okay? Do you understand? I'm giving you me.
So we have next Monday, and after that, we have 9:45 on the 26th for a status.
That's still by Zoom, Your Honor?
Yes. Okay. All right. Thank you very much.
Thank you, Your Honor.
And that's it.
Okay, so now June 22nd, 2026 at 3 p.m. in person for the hearing of this motion. Thank you all.
Why is all that? Okay, cool. That's not even as long as I thought it was going to be. Okay. Now, hold on. Wasn't this earlier today? Okay. All right. So this happened today. This is a hearing from today, which we'll go through here before I get ready for the petty.
So let's start with plaintiff's motion to compel responses. And let me start out with a question to the Reed. Attorney Rosenberg, in your opposition, you're basically saying the motion is moved because you
Who am
responded to
I,
the request on May
Patty?
21st, right?
As of filing that, yes, but I have an update that we
Hang
will
on.
have for you.
You go on to say in an email that's attached here, oh, I should also point out, in the submission that you made, you pointed out to the clerk that some of the exhibits that you had submitted were not complete copies. So for the record is clear, you submitted complete copies of 3 exhibits that the court has substituted for what was in there because they weren't complete, correct?
Correct. I think that relates to the other motion, however, but yes, that's correct, Your Honor.
So in your, there's an email in there as well that you say there will be a future production.
That's the update I have for you.
Is it all produced?
Yes.
Do you agree?
To be clear, I can't give you a definitive yes or no, Your Honor.
When did you get it?
Well, to the court's probably dismay, we were actually in a deposition this morning, which is nice to report. And
That wouldn't cause dismay.
I think the most confusing thing for me is differentiating all of the lawsuits. Which lawsuit is what? You know what I mean? There's just fucking so many.
it might cause shock. I don't know if dismay would come along with it. But that being said, Attorney Fell, my colleague, and I were in attendance for this morning's deposition, and Attorney Baylor is unavailable at the moment. I received an email on or about 11:24 a.m. this morning from Ms. Reed's
Y'all heard that?
acknowledging that a production to our supplemental request had been made. Following the completion of today's deposition, I got in the car and came here.
Let's not waste any more
Yeah,
time on
can't
this,
confirm.
right? You don't know, you just got it, you just said that.
Our team, yes.
Your team, yeah. We'll use it collectively.
All right, good, yeah,
okay?
that's fair.
All right.
Yes.
All right, so let's move on. We're done with that for now. All right? Anyone need to be heard any further?
Not this time.
You need to be heard any further?
No, Your Honor, not on that motion.
Okay, so let's go to the next motion. And that's the motion relative to compelling Mr. Allen. So, Attorney Rosenberg, and I guess to all the attorneys in this case, non-parties that are involved in the case, the pleadings I'm getting in this case, and I'm sure that I will get in the McCabe case, are replete with arguments presented as facts, which isn't really helpful to me. And there's a lot more background
I love that.
than I really need to decide the issues. So I'm going to ask all of you in the pleadings that you file, at least with me, just write what I need to know in order to decide the issue and stop pandering to social media. All right? So now let's get on to your motion. I have
Woo!
a question on with respect to the motion.
Yikes.
Can I just make one?
I gotta say, I like that.
Our memo, I agree with you, but our memo of law is 9 pages long and it has a page and a half of argument. So we're not pandering to anyone and we don't intend
You
to.
raised it, so let's talk about it. Let's go to page 3 of your motion, all right? And top page, we don't have to restate the.
I mean, that's a sign of being
End of the
fair.
first sentence,
I get
the
that.
end of the second sentence, excuse me, end of the first line.
Walk Your Dog people became a member. Welcome to the hoity goity.
I don't know, Your Honor, but
So is it really, you don't know, so is it really, what if he was a ring bearer? Is that really relevant to the issue I have to decide?
absolutely it is because
If a young child's in ring bearer at a wedding, okay, go to the line above there, okay, the words in quotes. Whose words are those? Because there's no.
This
reference,
judge
no
is spicy,
citation,
bro.
Which makes it totally not helpful to me.
understood, Your Honor, and that point is taken. However,
Well, who is it, do you know?
I believe it's her defense counsel.
Her defense counsel, you're citing a statement in quotes from your client's defense counsel. How is that relevant or appropriate, especially without citation?
But if I can take the first question first, and then I'll answer your second question. The first question, there's a significant relevance objection to Colin Albert being deposed or producing any documents in this case. You see it throughout the lengthy
I don't
opposition.
think the opposition is to producing any documents.
I would disagree with that, Your Honor, and I'm happy to explain why. But there's a significant relevance objection overall to Colin Albert being a
I know there's
deponent.
a relevance objection, but I don't think facts or plain facts like that are really relevant. They're nothing but attempts to sensationalize certain things. So let's go on to the real
Well, Your Honor,
issues. No, let's go on to the real issues.
Your Honor, if you're going to point out that something is irrelevant, I'd like to please just very quickly address why I disagree.
Now, this is a problem because I don't think that I get what the judge is saying. I like that he feels this way about pandering to the media and pandering to social media. I get that. And but the problem is that the things that he's talking about, it's not about pandering to social media, because there is a lot of social media talk, sure. And these are the things that are being said in social media. Sure, but these things are facts that are public record. So this attorney is trying to argue this. This stuff is relevant. This stuff happened. This stuff is relevant to their case. Some of this stuff is speculation, but most of us are really responsible about calling it speculation. Oh my God, Just Wim gifted 20 memberships. Thank you so much. Appreciate you. Thank you so much, Just Wim. I mean, yeah, that's the issue. Is like the issue is the reason why social media is talking so much about it and saying the things that we're saying is because we have all the documents. We've been following this case for so fucking long that the things we say on social media and the things that Karen Reed's team are saying are basically fact, and that's actually a sign to tell you that they're probably more likely fact, because it's what common sense leads you to. There's a reason why the majority of us feel the way that we do, because we've been following this like with a microscope. Dude, shout out to John Cuomo, fucking killing it right now. Like, I know there's people who like, you know, I don't think he likes me very much. That's fine. But credit where credit's due. The guy's been killing it. And he's been really, really, really pushing that. And while I'm on that issue, hold on. Thank you, X Nightmare, or just Nightmare. Okay. Gifted 10 memberships. Thank you so much. Appreciate it. Now, I reposted something on X that he posted. And I want to go ahead and show that, or talk about it anyway. I probably won't change my screen and show it, but so John Cuomo posted, the House defendants are trying to rally the troops to begin to flood social media with their mass posts. I propose, if we see a post from the House defendants side that we know is posting incorrect information, he was very specific about that, should we not directly respond to that person because it gives them the engagement and attention? Because you got to understand, that's what gets an algorithm going, is the more engagement and attention a post gets, the more it gets pushed out by the algorithm. So he concludes in saying, instead, we screenshot the post. Instead of responding to the post, we screenshot the post and then make your own post with the correct information so that you don't have to give them engagement. And then hashtag it with something such as House defendant misinformation. Hashtag House defendant misinformation. I love that. I love that idea. Because it's not about drowning out an opposing side. It's about taking information that you know is misinformation. You have looked at the data, you have analyzed it, and if it is misinformation, it's the right thing to do. To try to do everything you can to not contribute to the engagement of that post so that misinformation doesn't spread. And you could screenshot it, post something, and correct the misinformation. And so that's a really good idea from John Cuomo. I'm sorry I got distracted there. And Real quick commercial break. I don't know how many of you guys remember that I did this little thing on my Patreon, this little show on my Patreon. And I never really settled on a name for it. I think for a little while I called it I Fucking Ruined It. And I'm not married to that. But basically I take a movie. I share the link on my Patreon. So once you become a Patreon member, you'll have access to the link. And then we all get together and we watch a movie. And I will take a movie that you usually like very, very much. And I will destroy it. I will roast it throughout to show that it's really not a good movie, but we love it nevertheless. Christine Mitchell, they don't go to the deposition, but they can go to court hearings. Yeah. Interesting, right? Thank you, Christine Mitchell. So yeah, this happened today. This already happened today. So yeah, what I do is I've already done, there's people in the chat that have been there and have been to the Patreon streams, and I have done Top Gun. I showed how gay that movie really is, explained it all the way through. I ruined The Notebook for all you lovely ladies out there and showed exactly why that movie is just fucking awful. I ruined Point Break with Massamedia. I remember that. And a couple others. But thank you for becoming a member, Sherry. I appreciate it. Welcome to Reprobates. So I haven't done them in a while, but once in a while, I mean, it's just like why I do the petty streams. You must give the people games. So I would do these movies, and now I was recently in touch with an old friend, and I let them pick the movie. I gave some feedback and kind of, gave a little, but I ultimately I let him pick the movie. Or maybe I was the one who really picked it, but he brought the movie up, but I was just like, yeah, this is the one. But we're going to do Fletch, and I'm not ready to announce who the guest is yet. Once I announce who the guest is and we've settled on a time, it is not Rackets. It is a first time guest to the movies. Well, I've had this person on my show before. But this is a guest that you guys are going to absolutely adore. And it is the stream that nobody really realized that they needed. I'm calling it right now. Me and this person reviewing Fletch, watching it, laughing at it, talking about it, pausing it, giving commentary. Me and this person reviewing Fletch is the live stream that we didn't know we needed. It's going to be great. So I just wanted to give you guys a heads up. Keep your ear to the grindstone. Okay? Because we have not set a time yet. And it's going to be fun. No, it's not Annie. Although that's a really good idea, is to get Annie in on one of those. But no, it's not Annie. Stop trying to guess. I'm not going to tell you. All right. Let's continue with this right here. Oh my God, Christina, thank you for becoming a new member. I appreciate it. Thank you so much.
I've read everything. I know why you think it's relevant. It's relevant because they don't want to produce anything. They're trying to minimize the involvement. You're trying to do the opposite thing. I understand.
But you just told me you don't think it's relevant. I think I have the right to tell you why I disagree.
I don't need all that background, all right?
It's not background, Your Honor. It's a significant point.
Let's move on.
Well, how is the relationship?
Let's move on.
How is the relationship between?
We're either going to move on or we're going to end the hearing.
Okay, well, Your Honor, I would note for the record, I'd like to address the point that you just made.
I like this lawyer, man. I like this lawyer. He's not taking any shit. He's like, no. Hold on, man. Like he's making sure to get shit on record. I mean, it's fucking beautiful. He's making sure to get shit on record. And he's not just gonna like let the judge bark at him and sit him down.
Referring to something as irrelevant, which I think is actually highly relevant. If you're not going to allow me to explain that in 2 sentences.
You don't know how old the person was at the time they attended the wedding.
Correct. But that doesn't impact the relevance. The relevance is the relationship between the families. That's the relevance. And that's the only reason it's referenced there. I don't think the fact that the families were close enough to attend weddings together is relevant.
Done.
Whether Mr. Albert is relevant to this case. But I'm happy to move on to your other question. I think, I don't know if you can answer, but I take your point about quotation marks without a citation and the effectiveness of including prior statements of counsel. Please.
That was hardcore.
Not helpful.
Understood.
So now let's go on to some other questions I have about what happened here. Your office, not
That dude's a thug, bro.
issued a notice of deposition on February.
That dude was giving me some AJ vibes right there.
Over 2 months later, on April 29th, correct?
Correct.
And a subpoena was issued on April 15th.
Correct. Thereabouts.
No, well, that's the date.
Okay, that is.
Compelling production of documents 12 days later on April 27th. And the subpoena was not served for 6 days. Would you agree with that?
If that's what it says, I don't dispute the general point you're making.
So my first question is there a reason that you would wait 2 months after issuing a notice of deposition to issue the subpoena?
Well, there were a lot of moving pieces schedule-wise, as you're aware, Your Honor.
No, the notice of deposition said the date of the deposition.
Understood, but obviously those change.
Why do you wait 2 months, less than 2 weeks, closer to 12 days, to issue the subpoena and not serve it for 6 days?
Well, the service is dependent on the processor. I don't have an answer for you why it took 6 days.
No, it's not. The service is dependent upon the constable or whomever you hired to do it. Right?
Correct, Your Honor, but they're the ones that go out and try to
Maybe
find
don't
me.
wait until 2 weeks before the deposition.
Understood, Your Honor, and I don't disagree with you. But when that issue was raised, in no form did anyone on our team say to Colin Albert's counsel, you have to get us those documents in the 8 days because that's what the subpoena says.
That's what the document says. I'm going to remind you of the provisions of Rule 45, which says
It's a bad day, man.
okay, responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden.
Welcome, Cam Grader reprobates.
This is a non-party. You served a subpoena asking for 4 years worth of information to be served in a very short period of time.
And that
I don't think that's complying with either the words or the spirit of Rule 45.
And that's why, Your Honor, I don't have a problem with that. And that's why when that issue was raised, because there was a lot going on in the case, and it took longer to serve than probably we would have wanted it to. And so, Your Honor, when counsel raised that and said exactly what you just said, you've only given us 9 days to appear and 8 days to produce, whatever the specific numbers are. We said, we understand that. We are going to work with you on negotiating and conferring on the scope of the subpoena. And secondly, because of the time limit, we are going to reschedule the deposition so that we can resolve this document production issue, including when a production would be made before the deposition, so that Mr. Albert doesn't have to come back twice. So I'm not fighting you on that, Your Honor. I agree. And when it was raised by Mr. Albert's counsel, they didn't get pushback on that, on the timing. And so I'm not defending that. It was an oversight, I think. And I would prefer that it had been served 30 days before.
With all due respect, to someone that's represented by 3 law firms and at least 10 attorneys, it's hard to envision that it was an oversight that the deposition of a non-party deposition subpoena doesn't go out until shortly before the deposition and 2 months afterwards.
Your Honor, frankly, there's no basis.
I mean,
I agree with you. It should have been done sooner. And I apologize.
I mean,
and when it was raised by counsel, there was no pushback on it. And I think if you ask counsel, they will confirm that there was not pushback on the time.
Let's skip down to April and May. Now, am I correct that your office knew of Mr. Albert's availability and unavailability in the month of June? You made aware of it?
When?
in the month of June.
When? At what point? Eventually, on I believe May 20th. The email is an exhibit.
May 20th. So,
and May 20th, just to be clear, the explanation that we received was between now, May 20th, and June 2nd, Mr. Albert is available. We proposed, I believe it was May 27th and May 28th. After that point, Mr. Albert will be unavailable indefinitely, without an explanation. Frankly, the first explanation that we received was in the motion, or in the opposition to the motion. So yes.
I know you call into question the manner in which Mr. Albert's deposition was noticed by the plaintiff's attorney. And not arguing with that.
Dang, it's raining out.
Am I correct that you had notice of that deposition?
Were we aware that the plaintiffs plan to proceed with their deposition? Yes.
Yes. And even if the notice may have been deficient, as you referenced in your pleadings, you or your team, like you like to refer to it, made an intentional decision not to appear.
What was with that snark?
So
As you
first
like
of
to
all,
refer to it.
well, I don't think it is a yes or no question, Your Honor. We were aware, and we didn't file a motion. But again, I'd like to address why that is, if you're going to raise the issue. May I address that?
I know why you did, because you claimed you wrote about it. Why you did. It's in there, I read it.
Well, if you're asking about it at the hearing,
Man,
I'd like
this
to
is
address
bad, bro.
that. So what happened was we served the subpoena. As you say, we have a team of lawyers. Different lawyers are taking different depositions. The lawyer that's taking the deposition drafts, serves, and prepares the subpoena and prepares for the deposition. We did all of that. We complied with the rules, with your exception about date and timing is taken, well taken, and it won't happen in the future. However, otherwise, the subpoena was fully compliant with the rules, and the rules require us to be able to take the deposition. We didn't say it has to happen on this exact date. What we said was we will reschedule it to another date. The recipient of a deposition subpoena doesn't get to choose when the deposition happens by playing games like were played here and are laid out in our papers.
There you go.
Mr. Albert's counsel was
I
notified.
love that shit right there, bro.
That the attorney who was prepared to take Colin Albert's deposition was going to be away on 2 particular days that they had proposed. That one of those days, 6 days later, is the one that the plaintiffs chose. So the attorney who had prepared was not available, as was told to Mr. Albert's counsel. The notice, as you referred to, was issued in direct violation of Rule 30b-1. So we provided notice to all parties that we believed that deposition could not go forward pursuant to that notice, and we continue to believe that. But if the question is, did we come file a motion for protective order? No, because we don't believe we needed to.
Yes, sir. When is Mr. Allen going to be produced for deposition?
He appeared for that deposition on the 28th pursuant to subpoena, and then he is.
Hang on, let's lay the groundwork.
It's like, I'm not talking about what he already showed up to, bro. We're already past that.
When's he going to be available?
That happened on November 5th, 1955, bro. We're in 1985 at the Twin Pines Mall, bro. Calm down.
And I don't dispute what you're telling me, but I'm not going to simply rely on a statement in court that a witness can't be produced until the fall. So go find out when he can be produced before that.
Okay. I will, Your Honor. We won't talk to him until Saturday. I'll talk to him Saturday briefly and see what we can figure out.
But it's not a matter of figuring it out. It's a matter of you saying, look, there's a duly issued subpoena. As I said in one of my pleadings, in this case, which you weren't involved in, a subpoena needs to mean something. Just as an attorney agreeing to continue needs to mean something. And it shouldn't end up in front of me in these circumstances.
I appreciate that, Your Honor. We're in a situation where we learned on the 20th. We let them know the same day. I know they say there's games here. We informed them the same day that we found out this information that he had been accepted into the military and had a shipment date of June 2nd. We said, please take his deposition during that time. We want to take it. Is that what
Let's not put aside.
Oh my God. They found me. I don't know how, but they found me. Run for it, Marty!
Maybe a party that's going to prosecute an action such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And then when this ends, he'll go to 10 weeks basic training. We're not sure where that will be. The Army will assign him that location of where his 10 weeks of basic training will be. He'll be on, like I was saying, Your Honor, he'll be on leave in the fall. So, in terms of
Why the fuck you got your earbuds turned all the way up, man?
Discovery ends in this case.
Why am I gotta be responsible, dude? This YouTube thing, man, is a lot of responsibility that just keeps on like evolving, bro. Like, I gotta be responsible for people's feelings. I gotta be responsible for your fucking volume on your device. Get the fuck out of my face, bro. Turn your shit down.
Let's talk about the status of any discussions between attorneys as to the scope of the production. I agree with Attorney Tuxbury that the scope of the subpoena is excessively broad. I know there have been discussions, but
BBB.
No, the discussions are what are laid out. And if Your Honor is inclined to ask us to, we can continue to work on the document side, report back to you in a few days.
Yes, I mean, we made our proposal, Your Honor, with respect to, issues about what this case is about, which is the death of Officer Keith on the night of January 29, 2022. He searched for all communication with law enforcement.
Stop it.
We never got a response to that. And we're happy to look at other stuff here.
Like a little child.
Conversations, communications. Part of how we tied to this case.
That shit is never gonna not be old, bro. Or it's never gonna get old. My
I
bad.
don't know if you would want to, but I'm happy to get some thoughts from you about what's because what Mr. Tuxbury is referring to is the extremely narrow 2 categories that they said we'll search for these and we don't have any documents. We search and we don't have any documents other than the text chain that's already public record. So I think that is certainly too narrow. But I also take your point to me that as it stands, that the subpoena is too broad. There is obviously, as you are aware, Your Honor, there's more than wrongful death alleged here. The false narrative is part of the claims the plaintiffs have brought in this case, and that obviously relates to much longer than January 28th and 29th of 2022. So to the extent, A, there's burden.
I don't know that it extends 4 years.
And I'm not trying to argue it because I don't understand that you want to decide that as a fact right now. All I'm saying is it's broader, and this is kind of my point. I think it's broader than what Mr. Tewksbury and his team interpret it. You're telling us that you think it's narrower than what we interpret it, and that's taken, which is why I suggested we have a conversation about maybe meeting somewhere in the middle, and I'm fine doing that.
Have the conversation.
Tomorrow?
Yeah, I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting for something else tomorrow afternoon.
It's not me that has to call you.
I understand. It's, anyone, Damon can call me. I never know who has to call me.
Bro.
There's allocation of attorneys, so you need to know who you're talking to. But yeah, I can have a conversation about that. But obviously,
Now,
this is a wrongful death case.
We know who's out lawyered here, though.
In many respects, that false narrative claim is the other side of the coin of the wrongful death.
It's
She said things that someone else did.
glaringly obvious.
A priori false narrative. It's not the defamation case. This is not the harassment case, the criminal harassment case that's proceeding with respect to Mr. Carney in Norfolk County. And so we're happy to consult with them, look for more stuff. I think there's a disconnect because there's a different view of what happened here. And so I think they're frustrated when we say we don't have any documents because he simply doesn't have any. He searched. We're willing to consider searching for more and expand the time scope of that search. But, in likelihood, the answer is going to be the same.
I understand you stand before me representing a non-party.
Yes.
But we're all aware of the other case in which certain allegations have been made. So you're going to have to do some of the searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, I think, following the guidance of this court, this case is the wrongful death case. We're going to do discovery. We're doing discovery in the defamation case, and we're going to get document requests. I'm sure that would be broader than that. That's a different case here. And so the issue I have, Your Honor, as a third party here in this matter, is resource issues. Right? It's quite expensive here. We're going to have to do this in the defamation case. That's going to be different and separate apart from this one. So all I'm trying to do, Your Honor, is kind of ensure that I'm not needlessly harassing a third party here in this action. I appreciate what you're saying, Your Honor. We're going to produce those documents in response to the RFPs when we get them. Right? Obviously, we are. We've already gotten one set of RFPs from Ms. Reed in that case too. So I do appreciate. I'm standing here as a third party, subject to the protections of Rule 45 in this matter, and my client in this instance is also a party to a defamation case originally filed in Barstow County, now appearing before Your Honor. But I think in terms of like the scope of discovery and forcing him to kind of like do duplicative discovery, that's a little excessively burdensome. And so I think it's appropriate to keep our focus on what they want for this case. Yeah, like I mentioned before, it's not before Your Honor. We had thought that consolidation for discovery purposes might make sense to avoid this kind of situation, and it was rejected. That's fine. I'm not asking you to address it.
So
But
no, I don't think the hospitality defendants would really want to go on.
I will tell you, Your Honor, they actually said okay.
Didn't we just?
Not to speak for
What
them,
the
they said
fuck?
okay.
This was.
But that's these issues.
Didn't we already watch
I
this?
appreciate what you're saying with respect to the defamation case and discovery in that matter too. But that's why here, I think the appropriate scope for this case is, as you've laid out before, which is what happened to Officer Keefe on that night. And on that point, as we put out in our briefing, Colin Albert simply doesn't have a lot to say.
He's just going to start arguing.
Yeah, we'll consider Bert. No,
What depositions are scheduled for Monday? I should know because I asked you for the calendar. So I don't remember.
You know that Monday is Nicole Albert, but that's going to be that's a subject of a separate motion to compel. That's pending via 9A. That's going to be filed.
Oh, okay. Appreciate it.
Hate to ruin your weekend.
Got it.
Your team can review.
Hate to ruin your weekend. Ruin my weekend.
Talk about this again.
All right. Who gives a shit? That's enough. All right. Yeah. I know.
You suck.
Fuck you too.
Trace the signal.
Anyways, let me see here. So I got about an hour before the petty begins. Yeah, we're past that. We're past that. Creek, thank you so much. Appreciate you. Well, no, those don't count as members only. I do those. That's anyway. You know what I mean? Where we talk about the McAlberts and shit. Like that's just general audience shit. Petties are for my members. Yeah, see, let me explain, because I am gonna do a petty at 4 p.m. Eastern, and it's a petty that I had started to do, and then I was interrupted, ruined my petty, but it was a good interruption. turned out to be a really, really good, productive stream, and I'm glad that it happened. And I was gonna put it off. You know, I was like, all right, that's on the back burner again. Like at first, I wasn't gonna do one, and then I was like, just out of spite, I'm gonna do one, and then it's like, all right, well, now it's just like I'm gonna do one because I promised I was gonna do the spite one, and I never did. And then I was like, let me see how something goes first, and I'll make my determination on whether or not I do a petty on how that goes, and whether or not that person actually takes any accountability, and whether or not that person actually shows that, you know, maybe we had it wrong. And I was fair. I waited. I gave this person the benefit of the doubt. And I think I've more than earned the right at this point on a personal level to do a petty on this person. So it is set and it is happening 4 p.m. And it is members only. Ashley, thank you so much. So become a member if you want to attend. And guys, you guys are absolutely fantastic. Thanks for hanging out with me this afternoon and celebrating Free Day. Happy Free Day to all of you. Karen Reed was free a year ago, and now she is officially free because her probation's over. So now she's going to basically kick everyone's ass in civil court. And that's going to be fun. And then she's going to be like the new mayor of Boston, which is fascinating. It's a hell of a thing to witness in real time, man. I'll tell you, it really is. Turtle Boy was right. Absolutely. Guys, you guys are absolutely fantastic. Thank you guys so much for hanging out with me this afternoon and celebrating Free Day with me. And there's a 2:30 live about Proctor messages. Okay, thank you. I love you guys very much. Remember, it only takes a second to stay safe. Being retarded never stopped anybody from being a good neighbor unless you're a McAlbert. Guys, I love you very much. And we will do this again very soon, my friends. We will do this again very soon, my friends. Did you not hear me? Did you?
Watch out!
Today, being retarded means leading a full life. Retarded people go to work or school just like their neighbors and come back to a real home, a supervised home, right in the neighborhood where they belong. Being retarded never stopped anyone from being a good neighbor.